This is Michael Popok, Legal AF After Dark. Midweek edition of Legal AF, the leading podcast at the intersection of law, politics, and justice, only on the MeidasTouch network. Karen Friedman and me got together, brought our 30 years of prosecutor experience, 30 years of defense experience in courtrooms just like the ones that we talk about, and we brought it to bear on a new issue that just came up with a filing by Jack Smith in Washington, D.C. against Donald Trump as he prepares, the special counsel and his team prepare for the trial, the D.C. election trial against Donald Trump in front of Judge Chutkan, which is going to happen in March of 2024. What we discuss here, and for you to take a listen to, is the new motion filed by Jack Smith to try to smoke out right now and call Donald Trump's bluff about whether he is or is not going to try to assert a reliance on counsel defense to argue that he doesn't have criminal intent because he relied on counsel. Now, the only counsel that he'll try to argue he relied on are mostly or mainly indicted co-conspirators. Rudy Giuliani indicted, Sidney Powell indicted, Ken Chesebro indicted, John Eastman indicted, Jenna Ellis indicted, Jim Troupis should be indicted. So the fact that you're relying on people that are sitting next to you at the table waiting for their turn to be prosecuted and convicted probably is not going to bode well for your efforts. But Jack Smith wants to know it right now because it has an impact on the ability of Donald Trump to assert the attorney-client privilege over documents and information the government is still trying to obtain from 25 other witnesses, including these lawyers, including other lawyers for Donald Trump, including his own family members. Take a listen. So let me turn to the other motion that's getting a lot of attention, and we'll break it down from a legal standpoint that Jack Smith filed, which is to call out Donald Trump and his constant refrain through his lawyers on Sunday morning talk shows and in other places that they're going to use the advice of counsel defense. I want to talk about that for a minute. First of all, let me just explain what that is. It's not in the federal rules of criminal procedure. It's a judge-made defense. It's what we call in the business a affirmative defense, meaning the burden is on the defendant, not on the prosecution, to make out the defense. And the defense is my criminal conduct that you're alleging happened, I did in reliance upon counsel, reasonable reliance, we'll talk about that, upon lawyers, which the argument therefore goes, I can't have criminal intent. I can't have mens rea in my mind or in my heart because I was following the direction and advice of attorneys. And there's a number, as we know, there are a number of attorneys that have been indicted in Georgia that are also unindicted co-conspirators in Georgia and unindicted co-conspirators here in the DC case of election interference. Donald Trump was lousy with lawyers, giving him all sorts of harebrained advice that he followed or didn't follow, or he got what he wanted. He only listened to people that told him what he wanted to hear. And therefore you have people like Rudy Giuliani, Sidney Powell, Jenna Ellis, John Eastman, Ken Chesebro, Jim Troupis, and I could spend the whole show. This could be one of those skits on Saturday Night Live where the names just scroll from the bottom and it just keeps going through my entire presentation here. And Donald Trump used to collect generals and put them in his cabinet or his chief of staff position until he fell out of love with them. And he also likes to collect lawyers, especially ones that didn't tell him the truth. He had a group of lawyers that were on the government payroll that did tell him the truth, like the attorney general, except for the last couple, all the people that were acting as attorney generals, deputy attorney generals, White House counsel, deputy White House counsel, and most of the brass of the Department of Justice told him and his Homeland Security advisor, and we could keep going on, that there was no fraud that was determinative of the outcome of the election. And so instead, he turned Donald Trump to those who told him what he wanted to hear. Pillow guy, Overstock.com guy, supported by Sidney Powell, indicted, supported by Ken Chesebro, indicted, supported by Rudy Giuliani, indicted, supported by Jenna Ellis, indicted, supported by Jim Troupis, should be indicted. So whether Georgia or Jack Smith and his special counsel, the lawyers are front and center, either because they're co-conspirators, indicted or otherwise, or he's saying that I have a defense. It's very hard to have a reasonable reliance on people who themselves have been indicted for criminal activity. I think that sort of undercuts the argument, but that hasn't stopped Donald Trump's lawyers from going on television and saying that obviously Donald Trump relied on brilliant constitutional scholars. I guess that's Ken Chesebro, who's now indicted in Georgia, and John Eastman, who's now indicted in Georgia, for his belief. And we're going to argue that. All right. The reason that's important to Jack Smith and why he wants to know it now and not wait around until either December, when Donald Trump has to identify his witnesses and documents for the trial, or at some other later period, is because if Donald Trump is going to rely on advice of counsel, then he has waived his attorney-client privilege, his abilities to assert the attorney-client privilege as it relates to his communication with these lawyers. And these other lawyers to the government have asserted on Donald Trump or the Trump campaign's behalf the attorney-client privilege, because the privilege sits with the client, not with the attorney. The attorney has to do things to protect the privilege. But the privilege is waivable and waived or not by the client, Trump or the Trump campaign. And these lawyers like Eastman, Giuliani, Ellis, Powell, Chesebro have refused to produce documents, just as they did a lot of them to the Jan 6 committee that we'll talk about later, under the guise of attorney-client privilege. Well, there is no attorney-client privilege. It's waived if Donald Trump is going to rely on defense of counsel as a defense at the trial. The government wants to know it now because they're going to be fighting to get those documents from each of those people. And it's a lot easier if the judge has already ruled there's been a waiver. If there's not been a waiver, then we're going to have to go through what happened in California with Judge Carter in the Central District last year, when John Eastman alleged that his documents and communications with Rudy and Trump were all privileged. And the judge, after reviewing the evidence, decided that there was a crime fraud exception applicable, because the lawyers, at least the client, Trump, was trying to commit a crime using the lawyers' legal advice as a cover. And there's an exception to the attorney-client privilege. It's called the crime fraud exception, which is exactly what it sounds like. This is the second federal judge, that found that it was more likely than not that Donald Trump committed a crime. Judge Beryl Howell having decided, based on the evidence presented to her, that he did commit, it was more likely than not that he committed a crime at Mar-a-Lago, and therefore attorney-client privilege was waived. And that's how they got all of Evan Corcoran's notes and videos and audio tapes of his representation of Donald Trump from Mar-a-Lago. Judge Carter went first and ruled that John Eastman and Donald Trump were involved in a fraud and crime, and therefore waived the privilege and got the documents there. So Jack Smith just wants to know how many hoops he's going to have to jump through in order to get these documents, or if it's all going to be solved because Donald Trump is going to be made by the judge to declare now once and for all whether he's going to assert the reliance on advice of counsel at trial. They don't want to wait until trial to find out, because there's a lot of discovery that they need to conduct to get these documents from these people. That'll be a lot easier if that happens. So that's now been filed. The other side will brief it, and the judge will make the ultimate decision. So I guess, Karen, for you is, do you think the Judge Chutkan, is going to find the crime fraud exception applies and or waiver? And more importantly, do you think Donald Trump is going to say, yes, I'm going to assert that privilege or that defense, or no, I'm not? We haven't decided yet, Judge, just to make Jack Smith work for it in getting these documents.
So I thought a lot about this, wondering why did he go with the, tell me if you're going to use the advice of counsel defense, like you go on TV and say it in every talk show, right? That's one of the things he called him out on, and totally spelled out all the different TV shows he and his lawyers have been on, saying, oh, advice of counsel, advice of counsel, advice of counsel. And Jack Smith is basically like, okay, yeah, easy to say it on TV, but why don't you put your money where your mouth is and actually say it in court as opposed to on TV? Because, on TV, you're just saying it because you're trying to get people to believe you. But to say it in court and prove it is a whole other thing, because you would have to at least provide some proof of it in order to get the jury charge that says, it's okay to rely on, it could be okay to rely on the advice of counsel if it was in good faith and if you gave them full information. So, and so I was thinking to myself, why is Jack Smith going with the tell us now if you're going advice of counsel so we can get all the documents and all the discovery, as opposed to the crime fraud exception, as you so eloquently just described, what that is and why. And I have a slightly different take on it from, that it's just a little bit easier to do it this way. I think the reason he chose to do it this way, because he really could have gone either way, right? He could have said, I want all these documents and information through the crime fraud exception. I think he would have gotten it. I think to the way the other two judges found it, I think it's pretty clear. The reason, though, is because Jack Smith said there's at least 25 different people who this, including family members, who this would apply to if he were to say, I'm going to rely on the advice of counsel. And I want their information too, because there are going to be lots of people who provided the information to lots of different lawyers. And I don't know that all the lawyers helped engage in sort of the crime fraud exception, or all the family members, or all the other people. So it'll be interesting to see, but they don't all fall necessarily into the crime fraud exception, right? Some advice might have been in good faith, little pieces of it, some might not have, or some people might have given information to the lawyers that weren't necessarily Donald Trump. And so I think that the reason it was done is so that he has to say it, and then the discovery process would open it up to all of these individuals, whether or not they fall into the crime fraud exception. Like, it's very clear that Ken Chesebro would fall into the crime, fraud exception, or Rudy Giuliani or John Eastman. Those are very, very, very clear. But I just think it's a little cleaner to do it this way, as opposed to trying to get everybody's documents, that are tangential to the crime, to the actual lawyer in the crime fraud exception. So I think it's also for notice reasons, right? Jack Smith said, this way we know what we're going to ask in voir dire, right? We're going to, if you're not going to use that defense, or you are going to use that defense, it'll impact what questions we're going to suggest that are asked. So, that's another reason he asked for it. But they did say at least 25 witnesses withheld information and communications based on the attorney-client privilege. And so we'll see if we can get all of that. Do I think, just to answer your question, do I think that that the judge is going to do this? I think it's tricky because, the Rule 12 of the federal rules of criminal procedure spells out when you have to give notice of certain, when it's required to give notice of certain defenses, so number one, Rule 12.1 is alibi notice, or number 12.2 is insanity defense notice, and then, so on and so on. And there's a list. And, the advice of counsel defense is, Congress, I think they might say, look, Congress, if they wanted to rule on this and make it so that you had to give notice, Congress would have done that. And they didn't. And so, if I'm not going to make the defense do something, and then all they have to do is say, well, I'm not ready. I don't know. I haven't decided. And then what? You can't preclude it. You can't really preclude them from raising this if they decide to do it later. So I don't know. I think this would be one of those times where the judge might actually suggest it, ask it, but not require it. That's where I think she's going to fall on this one. Jack Smith is asking for specific information, like, the identity of each lawyer that provided advice that you relied on, the specific advice given, whether it was oral or written, the date, the information that that the defendant Trump communicated, that information that, was caused the attorney to render the advice. I don't think the judge is going to order him to do that, because it's not in the rules. And so as a result, I think she's going to say it's discretionary. When he decides what he's doing, he'll do it.
Yeah. I think she might make him disclose whether he's going to rely on it, but maybe this is the way, the third way, but not require him to give all of this discovery information that the government would normally be entitled to at this particular moment. But we're impressed with Judge Chutkan, how she runs her courtroom. She and Judge McAfee are making us proud to be lawyers and operate in courtrooms like this one. And there's just intellectual honesty about her rulings and her decision making. And we may not agree with it, but we understand where she's coming from, the case law she relies on, and her analysis. If you like that particular clip, that's just one of 4 or 5 segments we do twice a week on Legal AF, the leading podcast at the intersection of law, politics, and justice. Only one place, exclusively on the MeidasTouch network. Wednesdays, I do it with Karen Friedman Agnifilo. On Saturdays, I co-anchor it with Ben Mycelis, co-founder of the MeidasTouch network itself. And we curate the best stories. We put them together in a hot take, in a podcast just like that one. And then we release them as little podlets, little hot takes, to give people a taste of what the full-blown podcast is like. And then you can make your decision. That's why we're putting the content up again, because it's new information to you if you're not already a listener and follower and watcher of Legal AF. You can also get it wherever audio podcasts are found. Until my next hot take, until my next episode of Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.